and I head up the Employment and Dispute Resolution Group at Actons. I'm aware that we've got a number of people on the call who know us well and some new faces, so welcome to you all. Just a quick bit about Actons. We're a law firm based in Nottingham. We provide commercial and private client services to SME businesses and individuals across the East Midlands and beyond there. And I think today we've got an excellent range of attendees from London, Lincoln, Glasgow, Bristol, Redruth, the Tyrol in Austria, which was an interesting one, and also for the locals, Long Eaton. So welcome to those guys too. In terms of the plan for today, we're going to whiz through a few slides. We're also going to try and make it as interactive as possible. So we're pushing Teams to its limit with some chat functions, some polling functions, some Q&A, and some breakout rooms. So we're really keen that it's not just us talking at you online. That's pretty dull, well, dull for us as well as you. So hopefully that's all going to work nicely. We've got Matt in the background making sure all the technical stuff works well. So if you do have any queries, do pop those in the chat, and he'll do his best to help with those. In terms of the team, there's the wonderful team. James will be presenting with me today, but the other guys are on the call, as well as some other colleagues from Actons, and when we go into some breakout rooms a bit later, hopefully you get to meet some of those. I should also probably give a shout out to the Equinity teams and the Deloitte teams who are out in force, so it's quite likely that you'll see one of those guys in a breakout room as well, but you're super welcome. And just to set some context for today, it's been an interesting couple of years for HR people and people dealing with HR issues, and we're into a new phase, sort of post-COVID in the main, but that's bringing some interesting challenges, and of course that has the world has changed in pretty significant ways, and lots of what we're seeing clients talking about at the minute is managing a hybrid workforce. Some workforces are able to facilitate that kind of working in ways that others can't, and that's bringing a challenge in itself. We're seeing some employment law changes, not a lot of legislation, but some cases. I guess the government have been pretty busy over the last couple of years, not able to introduce much new legislation relating to employment law, or perhaps just partying. I'm not quite sure on that one, but there is definitely some change ahead, or at least review ahead, which we're going to touch on. We've also seen an increased risk of litigation, and that's both legal employee claims, but also, of course, the PR risk around HR and employment issues, P&O being the most obvious big one recently. And that does bring a whole new sort of level of risk for employers in terms of that PR side, I think, in a new way. And then, of course, other pressures, retention of talent, the great resignation, as it's being called, increasing wage costs, the desire to try and provide something more than just an increased wage because employers can't always do that. And that's really putting pressure on the people side of businesses. So we just thought it was useful to acknowledge that context. I guess say a well done to all the HR professionals and people dealing with people issues for getting through the last couple of years. It's not been easy, and I don't think it's going to be a particularly easy phase moving forward, unfortunately, as we try and navigate some of these issues. But hopefully what we talk about today will help with that. So that's the kind of stuff that we're going to whiz through today. James is going to pick up on some of those legal issues that are often missed when it comes to managing a hybrid workforce. So we're not necessarily going to talk you through the detail of how you do that. Actually, you guys have a better idea, I suspect, of how that works for your organization. But there are a number of legal issues that often get missed when it comes to this, and in fact probably have been missed over the years in ordinary times, but have just become more important recently. We're going to look at flexible working requests post-COVID. So actually, we haven't seen many of these yet, but James and I are predicting an increase in those as employers try and bring people back to the workplace in a way that they want them to, and that people aren't necessarily happy doing. So we think there's going to be an increase in those. Absence rates are up at the highest level ever, partly driven by COVID, but I think some of the knock-on effects of COVID, like mental health and just exhaustion for some people. So we're going to look at managing long-term sickness absence, and I'm going to talk you through that a bit later. And then we have lessons from the Employment Tribunal, so a few cases which are of interest and some other updates. That section will obviously come towards the end, but to keep you interested and on the edge of your seats, we can guarantee bad language, breasts, and baldness. So it doesn't get any better than that. It's definitely worth sticking with us. I know that the breakout rooms can often be an excuse to disappear. Please don't. It would be great to share some of those cases with you later on. So James is going to take control and kick us off with hybrid and flexible working.
Yes, thanks, Nick. I have control. Good morning, everyone. So hybrid and flexible working, to me, is probably the biggest recent change that most people have encountered day to day in the workplace. And as Nick just mentioned, I'm going to talk about some of the sort of legal issues that might be missed or are worth remembering when moving towards a workforce that's more remote or hybrid. And I make no apologies for going right back to basics. And the starting point for a lawyer especially is the contract. But as you'll all know, you're not actually technically required to provide people with employment contracts, but you are required to provide a statement of employment particulars on or before the first day someone starts work, usually done in a contract. And there's a load of mandatory things that statement has to include. And one that's perhaps overlooked, or at least was in the old world, was place of work. It would normally say something like, your place of work is the company's office, or such other place as we may reasonably determine within a reasonable area. And that would usually allow you, for example, the scope to move your office from one place to another within a sort of reasonable travelling distance. But for a lot of people, that's no longer going to be actually suitable for what their arrangement is. So nowadays, I think you need to be giving more thought as to whether that place of work is one place, if it's the office as it was before, or whether it's primarily home, or whether it's primarily both. And also, do we want to be building in the right to change it between the two? So say something like, your workplace will normally be from home, but we may require you to attend the office on any of your normal working days or on reasonable notice or whatever is required. So a bit more thought is probably needed in the modern world as to what statements of employment particulars, employment contracts say about place of work. Another sort of basic that can be easily missed is the requirement to provide a statement of any changes to someone's employment particulars, usually just done by a simple letter. Now, the most common one of those, if you're wondering what's he referring to there, is that thing that used to happen quite regularly and now with the cost of living squeeze may not do, where you get an annual letter that says something along the lines of, due to cost of living, we're all giving you all a slight pay rise. You might just think that's a nice letter telling you a pay rise, or employees might think that, but technically that's a statement of changes, changing the rate of pay clause in your statement of employment particulars. And the same rules apply for any of the other compulsory things that must be included in statement of employment particulars, including place of work. So if people are going from 100% office based to a varied arrangement that's permanent, then there should be a statement of change telling them what the change is. And those types of statements should be provided or must under the law within 1 month of the change taking place. Now, I mentioned home working provisions in the context of place of work clause, but it's also worth considering home working provisions and hybrid working provisions, because that will include usually an element of home working in some of the other aspects of the contract. So I've mentioned the first bullet point on the slide, place of work, but you also might want to incorporate it into things like probationary periods. So for new employees, home working might be something you're not sure will necessarily work, or that you don't necessarily want to grant from day one. So whilst you could have a normal probationary period in terms of overall suitability for the job, you could also have a separate probationary period built within the home working provisions of the contract. to allow greater flexibility, and to assess whether home working is suitable, because not every employee necessarily has appropriate personal circumstances to work effectively from home. Some do, some don't, and you can test that out. And as the third bullet point says, usually as an employer you want to retain flexibility to change things if they're not working. So incorporating express rights to terminate or vary home working arrangements on notice is usually a good idea. Change of address. I mean this in a slightly different context from the address of the employer that I was mentioning earlier. I'm talking here about the address of the employee. So if your employee is home based, either partially or fully, then it's worth noting that in their contract or statement of employment particulars, but also putting an obligation on them to inform you if their address changes. Because I've certainly advised in years gone by on home-based employees, and changes of address have caused problems. An employer once contacted me saying, "Oh, we've just found out that our employee has relocated to the Republic of Ireland, and so they can't make the meeting in Hatfield." And it turned out they'd moved quite a while ago. It's just that problem hadn't emerged, and it set off a whole chain of events. Whereas if they'd have been under a positive obligation to say, "I'm planning to move there, or I'm going to be moving there," then perhaps that issue could have been nipped in the bud before it arose. So that's something to think about. And another big change that a lot of organisations have had is when people work. The sort of days of 9 till 5 are perhaps reduced for most people, and employers are more concerned about output and just getting the hours in. And that of itself could cause slight operational issues if you have workers that perhaps work slightly unusual hours, and they get up at very early in the morning, do a good few hours, take a break, and then reconvene in the evening. And it turns out you've got no one to service your clients between 10 and 3 because they're working strange hours. So do you want to impose core hours, even if you're not mandating that they must be at their PCs or other workstations 9 till 5? Do you need to make sure that they're at least available between 11 and 3 or whatever operational requirements demand? So being a bit more creative with home working provisions and contracts, and thinking about it before you just send off the standard precedents, is something I'd really recommend looking at. Similarly, health and safety considerations. I'm not intending to go into that any great detail, but you're more likely to have more guidelines, instructions, questionnaires that you'll need people to complete and comply with, and a sort of a reference to that in employment contracts is worth considering, so that you're covering all bases. Other practical considerations. Own device policies. They were becoming more and more popular even before the pandemic, because people had their own iPhones and laptops and were logging in. And whilst that's often great, it can create its own problems in terms of data security and confidentiality. So if you don't already have own device policies and people use their own devices frequently, that's something that's worth looking into. Other things I've flagged: expenses. Often employees might say, well, now I'm working at home, I have to up my broadband speed, or I'm using the landline if people still have landlines, or other mobile phone costs. Who covers that? I mean, there is no rule to say that employers have to cover these costs, but you don't want to create ambiguity. It's best for all parties if everybody knows where they stand. Equipment and insurance, similar. Does the company's existing insurance or the organisation's insurance cover it? For example, if an employee takes their laptop home, is it still insured in the employee's home? If not, do you need the employee to have it insured whilst they're at home? Does their insurance cover that? So it's just looking into those issues and ensuring that the contracts can cover off the situation if needed. Other things that perhaps practical things emerging from working from home: accident reporting. So you could, in theory, now have accidents in the workplace at someone's home, and they need to be treated in the same way as the ones at work, albeit obviously not all accidents at the home will be workplace accidents. It will be a context dependent. And another clause I'm seeing more and more frequently in employment contracts is right to enter employees' homes. Now, clearly that's going to need to be a limited right. You can't just be going in whenever you like, but there are certain circumstances where employers are going to legitimately need to go into employees' homes, such as to perhaps maintain equipment, fix equipment, undertake risk assessments, or sometimes at the end of employment this can prove problematic. Right to enter to reclaim property, and if that's expressly stated within contracts and worded reasonably, there's no reason not to do that, and I'd recommend it in many cases. And similarly, I mentioned on the previous slide about data protection and confidential information. Policies and procedures on those need to be updated to reflect the fact that people are working from home, whereas perhaps in the past it was primarily focused on office-based arrangements. And a reference to compliance with those in employment contracts is worth having. Flexible working requests. Now, before I talk too much about flexible working requests, sort of a theme of this talk will be a lot of this stuff is in the news, and a lot of the time the news can be misleading, or terms can be used interchangeably when in an employment law context they have certain meanings. So people might often talk about, oh, we're working really flexibly, but a flexible working request is a specific legal process, and that comes via statutory right in the Employment Rights Act. And as the law currently stands, all employees with 26 weeks continuous service with their employer have a right to make a flexible working request. What is a flexible working request? Well, in effect, it's a request to change their terms and conditions of employment, either permanently or temporarily, in relation to the hours of work or times when work is required or place of work. You can request other things, but they're the main ones. You're only allowed to make one request, at least under the statutory regime, per 12-month period. Clearly, you can make as many requests in a sort of informal sense as you like. And there is a strict legal process that needs to be followed if such a request is made before a decision is taken, which I'll come to. I don't plan to go into that in much detail because I'm sure as HR people you'll know broadly what that is. But where there's been a lot of talk in the media about flexible working is this concept of making flexible working the default. And without much further information, I've been sort of thinking, well, what do they mean by that? And all I could come up with was, at the moment, an employee makes a request and the employer has an obligation to consider that request reasonably. And if they don't want to grant the request, they have to provide one of a certain number of specific reasons. I'm assuming this default position will be something along the lines of employers are required to make attempts to accommodate the request, and they sort of work from a starting position of, right, we can do this, why can't we do this, rather than what shall we do, is it possible? But we'll have to wait and see if that reform actually comes along. Because as Nick was saying, so far, we've not noticed a great increase in flexible working requests, probably because these issues have been something that employers have just had to deal with because of the pandemic, and resolutions have been met informally. But on the flip side, as Nick said, we've noticed a tendency for certain employers to want people to get more back to the office. I mean, you'll all have read about Jacob Rees-Mogg and in his memo to the civil service. It's open for employees to say, well, I know you're saying I have to come back, but I don't want to. I want to permanently work from home. I'm making a flexible working request, and that will put the onus back on the employer to make a decision that could have ramifications depending on what it is. Which brings me to my next slide. So when you get one of these requests, what are the main problem areas? Well, the current law says you just have to deal with it in a, quote, reasonable manner, which is a relatively loose concept. And as I alluded to, a refusal has to be based on one of the permitted grounds. And one of the easiest ways for an employer to trip over is to not rely on one of the allowable grounds for rejection. If I read a couple of them out, they'll probably all come flooding back to you. Burden of additional costs, inability to recruit additional staff, planned structural changes. There's a whole list in the Act. You've got to make sure that you use one of those, even if you then go on to explain using more kind of understandable normal language as to why you're rejecting it and why it falls in one of those headings. And requests don't have to, under the current law that's been enforced since the much more complicated system pre-2014, they don't have to be resolved very quickly. You've got 3 months, which includes any appeals process that you have to resolve them within. And in theory, you can agree a longer timescale, for example, if you're going to do some kind of trial. So that's worth bearing in mind. I think the big change that I can see, though, is what I've described as pandemic precedents, where in the old days, you'd have someone come to you and saying, usually someone who's been working office-based and they've perhaps had a change of personal circumstances, I want to work from home. And I'd often get a call from employers, and they'd be very nervous about this idea of people working from home, and they would look into whether they could justify it and grant it. And on many occasions, they'd be quite cautious, saying, no, we just don't think we can for various reasons. Whereas now an employee is potentially going to come loaded with a raft of evidence along the lines of, since 2020, when we all got sent home, I've done X, Y, and Z, and it worked absolutely fine. And that will make it a lot harder for employers to say, well, it's just not viable. If it was done successfully for quite a long period of time. And so your threshold of saying it was reasonable not to grant the request will probably be a lot higher if there's significant evidence that it can and did work, rather than it being a more sort of speculative exercise. Right, this is the first interactive element. That signal is for the polls. Shortly, I've got one more slide after the polls, but we're shortly going to break out into breakout rooms. And one of the things I'm keen to discuss is the outcome of the polls. So we've got a series of questions. Hopefully the polling will be emerging for you to answer shortly. Hopefully someone will nod and say the polls are going to appear. Here we go. So the questions should be emerging on your screen. I can certainly see one. And if everyone can keep it, hopefully the results will be live, and people can keep an eye on where the polls lie, because it'll be hopefully provide some food for thought for the breakout rooms. So looking at my results so far, it's certainly the hybrid working option is the majority. 76% between 50 and 100%, 25% less than 50%. So that's interesting. Should we move to the next question? So this question, do we consider hybrid working increases or decreases your organization's overall efficiency? And we've given you quite a variety of answers, because it's not the easiest question to just have a binary yes, no. Well, you might think it is. We'll see. The responses are growing. So we've got 38 responses so far. The leader is it both increases and decreases efficiency. So I think that's definitely one for the chat room, or the breakout rooms, I should say, as to why that is and what the pros and cons are, and what issues people are seeing as to why it's decreasing efficiency in particular, because not many people have said overall it decreases efficiency, but there's obviously a sentiment that in certain situations it does. The third question, just want to see what the group we have today, what their situation is, just so we can put that into context, your current working relationship. Well, I say relationship, arrangement. And in particular, this quantity for those that aren't fully one or the other. Interesting, a very high proportion. Oh, it's only 6 responses. I'm jumping the gun. Yeah, so pretty even split there. It's the 4 bars are all evening out. Interestingly, office-based is the loser. Most people are, at least to some extent, working in a hybrid manner. We're down to 12% as the responses come in for office-based. Oh, I think we seem to have lost the results on that one. Hopefully we'll get to the 4th question shortly. Right, a bit of context for this question. I'm not sure if you've all read this part of the news, but there's a law firm in London, actually one who our firm was dealing with recently on a transaction, who were introducing a pay cut of 20% for those lawyers who worked fully remotely, it was a London-based firm, so I assume, although I didn't read into the detail, that it was potentially linked to London commuting costs, and that was the justification for reducing wholly remote workers' salary by 20%. And it raises the question, in light of arguably reduced costs, should remote workers be paid less? I'm not surprised by the results on that one so far. Yeah, that was the general outrage that seemed to emerge from that story in the press. Although there's a few people that have picked my option that included London. I don't know whether I should have shame we can't have an additional question of are those people from London or outside. I strongly suspect outside, but we'll have to assume that. And there's one final question before we move on to the one slide before the breakout rooms, and this relates to buildings or the way you use your buildings. So did you not have hot desking, and do you now? How has anything changed as a result of hybrid or remote working? And because I'm guessing that yes is going to be the winner, I've nuanced it slightly. Is that just a little bit or a lot? It's interesting. Early results say not that many significantly. So by significantly, I was anticipating a certain percentage of organisations will have simply ditched their physical office space and have worked to some kind of shared service system or not got anything at all and let leases expire, for example. But it seems to be more of a middle ground. People are a bit more cautious, 54% with a certain percentage of no. It's actually quite a high percentage of no at the moment, 29%. Right, so keep those poll questions in mind because they'll be food for thought in the breakout rooms. We also have some other points that we're going to touch on for discussion in the breakout rooms. So hopefully you can all see the slides again. The problems that we anticipate emerging in the workforce because of hybrid or remote working is issues about work allocation. There's a temptation if many people are in the office and a few people at home for the people who are in the office to get the work, and people are at home get forgotten. And it's about ensuring as organisations that doesn't happen and putting systems in place to ensure that people are treated equally wherever they are. Because clearly that could lead to various types of employment claims, whether just claims relating to unfair dismissal for being overlooked or in certain circumstances discrimination, depending on the reasons why they may be working from home. Absence management. I'm not intending to sort of step on the toes of Nick's section on absence management later on, but I have had a few interesting queries since the pandemic regarding whether people are actually calling in sick anymore because they're not following the normal rules because they don't need to come in. So why do they need to ring in? And for most organisations, that the normal absence management rules still apply, so they should still be being followed. And secondly, are people actually sort of working at home while sick and not really working? Is that a new problem that's emerging? Clearly, if you came into the office and were feeling unwell and had a bit of a lie down, people would spot it. If you're just working from a desk, is that the case? And then finally, this friction between office-based and home-based staff. Are we starting to notice that? I went to an interesting seminar recently where the speaker described it as the home bunnies and the office bees, and the growing tension between those two factions. Are you encountering that? And if so, how are you resolving it? We're shortly going to move to the breakout rooms. I think I can move to the discussion points before we do, so we don't miss that. So further food for thought on the breakout room discussion about hybrid working and the poll results. The ONS recently reported in May that 24% of workers are hybrid working, but 84% want to. So that's interesting, the level of popularity. Is that going to decline over time? I've noticed a slight decline of people wanting to work from home all the time, but perhaps a greater appetite for people to work from home to some extent than existed pre-pandemic. Is the division between home working and office-based working linked to pay, because the figures show the lowest earners are least likely to be hybrid working. Do we agree with the 78% who think there's an improved work-life balance as a consequence of hybrid working? We've already touched on the increasing or decreasing efficiency. I mean, I've put some further thought. I mean, a lot of people think it's quieter and therefore improves your efficiency, but is that at the sacrificing of collaboration and innovation and impromptu meetings? We've looked at the pay issue and how a physical workplace is adjusting. So hopefully Matt will break us off all into the breakout rooms and we can have a few minutes to discuss these points a bit further.
So a bit of a change of focus onto managing sickness, absence, although we're going to keep it interactive, and we're going to have a quick poll, which hopefully Matt will be able to send our way. So I like, again, this is a bit of a running sort of competition for me in terms of the longest period of continuous employee absence that you've either dealt with or are aware of. So the options we've got are someone was off sick for up to 2 years, between 2 and 5 years, between 5 and 10 years, or more than 10 years. So let's see. Sorry, actually more than 19 years is an option there, which would be astounding. Okay, a couple of responses still coming, but a good chunk of absence at the up to 2 year mark. Actually 18% between 5 and 10 years, which seems like a really long time. I'm going to add my polling result there, which will change something slightly, because I'm going to share a little story just to set some context. Now, if you spotted the poll result, you might have noticed that one. But I had an inquiry from a new client many years ago who said, we've got a long-term sickness absence issue, Nick. And I thought, oh, that's great. That's the kind of thing that I do. It's my specialist subject almost. And I said, how long has the individual been off? And they said, he's been off for 19 years. And I said, sorry, you mean 19 months? And they said, no, 19 years, we forgot about him. So I was suddenly then feeling less comfortable with the whole situation. But essentially, they wanted me to risk assess that particular case and help them resolve it. And I won't bore you too much with all of the detail, but essentially this particular chap was a lawyer, actually at a financial institution in London, not a bank. And he had fallen out with his manager. He'd gone off sick with stress and depression. And his manager had then left. The HR team had then changed, and he had moved on to a permanent health insurance scheme. And every year, a nurse from the insurance company went out and said, "Are you still stressed and depressed?" Yes, tick the box. And he was getting 75% of his salary every year for 19 years until he, with an inflationary increase, of course, until he walked into reception and said, "I think we better bring this to an end." And of course, the receptionist said, "Sorry, who are you? We've got no record of you," because the HR folder, as it was then, paper folder, had gone into a filing cabinet and disappeared. So quite an astounding story. What was even more surprising was that actually his family had no idea that he was off sick, which actually was quite sad. So he got up every day, put a suit on, and walked out the door. Yeah, so that was the longest sickness absence, 19 years that we've dealt with. So hopefully that's reassuring, and that if you've got any long-term sick issues, it's maybe not quite as bad as that. And we did resolve it in the end, although it involved quite a bit of money and many apologies on the basis that it wouldn't have played out well in the employment tribunal had they told the employment judge that they'd forgot about one of their employees for 19 years. So that's a little interesting story. The reason we're talking about this today is the latest stats as of 2021 showed that sickness absence rates had increased quite significantly, actually, and that they're now at the highest since 2010, and that 150 million days were lost to sickness during that year. Now, actually, a reasonable percentage of that, unsurprisingly, was as a result of COVID. But actually, even in 2021, there was a decent increase on the previous year. Now, I think actually some of it will be COVID. Some of it may well be other issues linked to COVID, such as exhaustion, mental health issues, and certainly on the mental health front, we are seeing an increase in those kind of issues with clients. So navigating some of that is tricky, and hence why we are going to look at it in a bit of detail today. What we also like to do is just set some of the context in terms of the legal risk in this area before we go on to actually kind of managing absence. Clearly, if we're looking at a long-term absence, or I guess even persistent short-term absences, often when we get involved, it's either trying to help get the person back to work effectively and looking at adjustments to do that and getting good medical advice to do that, or if we're honest, more commonly, working through a process to dismiss that person from the workforce fairly, which can be done with sympathy and kind of compassion in that way. But actually, sometimes it's just not good for the person or for the organization for them to remain there. And that's where we would help. In terms of legal risks, that generally revolves around unfair dismissal. So we're looking at having a fair reason for dismissing, following a good process, but also disability discrimination, because if the condition that the person has meets that statutory definition, then they may also have a disability claim. And we also obviously look at various things like adjustments and that kind of thing as part of that. The reason for mentioning that is they cost money. So claims along those lines would result in loss of earnings claims for unfair dismissal, and for disability discrimination, loss of earnings and potentially injury to feelings awards, which can be fairly significant. Obviously, there's also the impact of absence on the business, paying for sick pay, the impact that it has on colleagues when an individual is not at work in terms of picking up their workload and that kind of thing. It's also, though, worth remembering that not every condition will be a disability. Again, people often get a bit sort of het up about the fact that someone's off sick. Oh gosh, we must be careful. We have to leave them alone, not talk to them, that kind of thing, not engage with them, because actually it might be a disability and we might, make a mistake. It's definitely worth looking at the statutory definition. I thought actually to try and make it interactive, if somebody fancies looking up the statutory definition of disability discrimination and posting it in the chat, you'll get brownie points. And it's also worth remembering that if it's clearly not a disability, if someone has a cold, the chances are it's not a disability, then don't treat it as one. And if there's doubt about whether it's a disability or not, it's very often hard to know, particularly before you have medical advice, then you might decide to treat it as one, because actually what you're doing is engaging with that individual positively in a way that helps you understand what they're experiencing, what condition they have, and that kind of thing. So in some ways, it doesn't make a difference, I guess is what I'm saying, whether it's a disability or not. You're still managing the employee and you still need to engage with them. Vicky is first off the mark. Well done, Victoria. Good to see you. The other thing that I wanted to highlight, because again, people often get quite frightened of this area, is that there is some tribunal case law which helps support taking a more robust approach with these things. And this was a case with a teacher, Mr. Herry, who I think brought a huge number of grievances. I think it was both disability and race discrimination allegations against his employer. I think it was a teacher. And the tribunal in this case considered that the distinction between stress and mental health or a mental impairment, the latter of those obviously being one that might well constitute a disability. And I think it was something like a 34-day tribunal. It was absolutely crazy. But the judge in that case basically said that an unhappiness with a decision or with a colleague, or a tendency to nurse a grievance, or a refusal to compromise are not of themselves mental impairments. So just because somebody's not happy about something, or because they're stressed about it and go off sick, doesn't necessarily mean that they will have a disability that meets the definition for the purposes of the Equality Act. And I think that's just worth remembering. Often, these things get messy with sickness absence in particular, where there are other processes in play, like a disciplinary, like a grievance process or a performance process. And actually, it may be that we're able to take a slightly more robust approach with the right process to try and resolve these issues. We'll come on to some of those tricky issues in a little bit. In terms of managing long-term sickness absence, we take quite a kind of a robust approach with it, but one that is a methodology designed to protect the organization in these situations and try and either help the employee back to work, or sometimes they will leave the organization. And what we are essentially doing is balancing the needs of the individual, but also the needs of the business or the organization, and essentially risk assessing that situation early on so that you can take the appropriate steps as you go through the process. And there are effectively three strands, as I describe them, to this process. The first of those is consultation with the employee. So updating them on how things are, getting updates from them as to how they are, considering adjustments, taking medical advice and talking to them about it. So consulting with them about medical advice. Medical advice is the second strand, and you'll hear me talk about medical advice a lot because it's so important when it comes to this particular issue, because you as employers, and in fact also the employees, even though they're experiencing a condition, are not medics. They don't actually know exactly what their condition means for them some of the time. So it's worth getting a medical view. And that third strand is then the business need. So employment tribunals will actually consider the impact that this sickness absence has on the business. Although the tribunals often work on sympathy and they start very much in favour of the employee in our experience, they do take into account the impact that sickness absence has on the business, and they appreciate that most businesses are not charities. Obviously charities are charities, but most businesses are not charities, and even charities working in that sector cannot afford to sustain long-term absence indefinitely, and therefore they appreciate that things like that have to be dealt with. So just to touch on medical advice to start with, often it will be, well, almost always it's important to have some kind of medical advice. That might be a sick note from the GP. It might be that you want to contact the GP for more information, but you might also have an occupational health provider that you work with, or one that you approach in a particular situation. Or in very complex cases, you might actually want an independent expert in that particular condition who specializes in that area in order to give you a view if it's very complex. And I've certainly had a number of those cases where we've gone to very, very well-regarded experts who know quite a lot about very unusual conditions where it's been necessary. And there are pros and cons as to which of those you choose. Clearly, the independent expert may not be appropriate if it's a very simple case, not high risk, but if it is incredibly high risk, you might want, or complicated, you might want an independent expert. Occupational health are very useful because they bring the medical side, but also an understanding of workplaces generally. So that really helps with that business need strand that we were talking about, as well as the medical side. And unfortunately, and I have to be careful about slagging off GPs, because I've got in trouble with this before, where people are married to one, or that kind of thing. But generally speaking, from the employer's point of view, the GP is not particularly helpful, because often they will just repeat what the employee is telling them and not really take into account of the business side of things. And understandably, they are responsible for the employee's care, and therefore tend to be very positive as to their side of the situation. They're also very busy, and therefore often don't have the full picture when it comes to understanding what's actually going on. Employee consent with all of this is really important. Again, I'm not going to go into the detail around all of that. In particular, not the detail of the GDPR. That would be even more boring, or the Access to Medical Reports Act. But it's worth remembering that we can't just look at an employee's medical evidence or records or a report that's produced without their consent. And it may even be that they refuse to give that. And sometimes it's then the case that we need to explain to them that we would have to take decisions in the absence of medical advice, and that isn't something we want to do. But if they refuse to engage positively with us on that, then we might have to. So that, again, often is an issue where things have become particularly contentious, and the employee won't actually cooperate, and therefore one to keep in mind. So one of the other things that we do a fair amount of is helping clients get great medical reports. So anyone who's commissioned a medical report in these kind of circumstances has likely come across very, very unhelpful phrases like the individual will be off work for the foreseeable future, or things along those lines. Now, if anybody else knows what the foreseeable future actually means, do pop that in the chat, because I've got no idea. And it's incredibly unhelpful as an employer when you're trying to manage the situation, both from an internal point of view in terms of how long do we need cover, how long are we going to have to pay sick pay for, when will they be back, who knows, but also in terms of this methodology that we're talking about, in terms of when can we bring this to an end. So it's really, really important that we ask the right questions in order to try and maximize the chances that we get the right report, the right outcome. And that can involve setting the scene well in a referral letter. So again, referral letters are often just, this person's sick, please help us, give us some information about what's going on. But actually providing information on what they do, the fact that you are serious about your duty of care to them, the history that's led up to this, things that you've already considered, and importantly, the impact that it's having on your organization for them to be off sick is really important in rebalancing things and ensuring that that medic doesn't just take the employee view into account as part of that. You might ask them if they need to see medical records, because again, if it's not the GP, they may not have access to those, and we need consent for that. And also not asking about disability. So this is often a very controversial thing for me to say. Nearly every referral form that we see says, does this person meet the definition that Vicky very kindly posted in the chat? And that is a protection thing. Where I think employers in particular are thinking, oh gosh, we need to know this because it will change what we do. But in reality, as we talked about earlier, I don't think it will change what you do. And there's a number of reasons for that. The primary one being that actually, what will you do differently in terms of managing that employee? You might be more careful. Well, you probably should have been being careful whether they're off sick. Be careful, whatever the condition is. Secondly, a medic can't actually tell you whether they meet a legal definition. And in fact, we can't tell you, because the only person that will decide that is the employment judge, should you end up in the tribunal in front of a claim, and they will decide that for you. We can give you some advice as to whether it's likely, but the only person who will ever be able to decide that is the employment judge. So does it really make a difference? And secondly, and this is a bit of a technical point, but one that I've seen trip an employer up before, is that if that medic comes back and says, yes, that person does meet the definition of disabled, then actually when you end up with a disability discrimination claim in the employment tribunal, the first thing you might want to do is actually dispute whether the person is disabled in the first place. That would be a perfectly valid defense to say, well, actually, they don't meet the definition, so the whole claim falls away. And if you have a report that you asked for which says, yes, they do meet the definition, then we're on the back foot straight away. And given that we wouldn't ask for given that we wouldn't want that to happen, and we wouldn't treat the person any differently in any event, is my suggestion, then does it really matter? So that can be a bit controversial, but I would nearly always suggest taking that question out, because you're asking enough other information to deal with the issue. Let's not kind of trip ourselves up with that particular one. So we've got great medical advice. I suppose the other bit that I would recommend is trying to ask questions that sort of nail down a definite answer. And also, if you don't get a definite answer from the medic, going back and saying, please, can you be clearer on this? So again, people are often reluctant to kind of push medics for definitive view, because they often avoid giving one, but it's really important, and I would suggest going back to them. The other thing that you can do is just phrase questions in the right way, and again, we do a lot of work with clients helping them phrase those questions so that they can't really not answer it in a way that's helpful for you. So you've then got your medical advice. What are you going to do with it? Well, you're going to read it and you're going to analyze it, and you're going to work through that with the employees. That's part of the consultation strand that we talked about. You're going to consider if there are any adjustments or any things that might actually help the person back, because obviously if we can do that, one, we're under a duty to do that, but actually that might well be the best outcome rather than them having to leave. But it's important to consider whether a return is likely, and that's a key part. And then matching all of that information that you have against the business need. And the obvious one there is, well, our business need is for someone to be back within 3 months because we've got a really big project, or we're in retail and actually the January sales are crazy. Christmas is crazy, January sales are crazy. We need everybody at work. And the medical advice says this person is going to be back for 9 months. Okay, well, there's a good reason for us to be able to bring it to an end more easily. And the other thing, just again to be clear on, is and not miss out on, is that actually there may be other alternatives to dismissal if you get to the end of that process and you haven't considered things like ill health retirement. So again, I was seconded to a bank who had a really generous ill health retirement policy, and I helped them work through analysing whether people met the definition to get that, because there were, I think, too many people were going through on that grounds. But it's one that's really important to consider, as well as permanent health insurance. So the 19 years guy, he obviously went on to that kind of insurance policy. They're a great benefit in some ways, but you can get stuck in that kind of situation. But if you haven't considered those as part of this process, then you're likely to come unstuck too. Tricky issues we touched on a little bit in terms of things like disciplinary grievance process or performance processes, and often that is people refusing to come to meetings because they're off sick. And I've had a few clients that have approached this in different ways, one of which was to not pay sick pay in circumstances where someone wasn't coming to a disciplinary, for example, because they took the view that it was an obvious tactic to avoid a disciplinary sanction. But it is also possible to get medical advice as part of that process around absence, which explores whether actually it would be helpful for the employee to attend a grievance or disciplinary meeting in order to help them get better, remove the stress. And it's really helpful if you have a view from a medic which says, yes, I think that would be really helpful for them to just get this done, because having it hanging over them is not a good idea. So asking questions around that, which will help with that, that process obviously helps keep things moving and brings things to a resolution too. Cancer's an obvious one. To mention too, it's automatically a disability, so actually in some ways that definition doesn't matter, and you may well decide to approach it differently and consistently, ideally. So sometimes people will look at a policy, so we're wary of kind of having a policy for everything, but assisting managers with dealing with what is obviously a really distressing situation is sometimes helpful, and ensuring consistency when you're dealing with that particular issue. But essentially you're managing things in a similar way. And a new one on this set of slides that we use fairly frequently is long COVID, because of course it wasn't a thing until fairly recently. And the ONS are estimating that 1.8 million people are suffering long COVID symptoms, and that's clearly a lot of people. Interestingly, the Equality and Human Rights Commission was tweeting about this recently, and initially I think the first day said, oh no, it's not going to be a disability, and then the very next day said, oh actually no, it could be. So there's still some uncertainty, but in reality it will be treated as any other condition, and if it meets the definition, it meets the definition and therefore will be a disability. It may well be that the symptoms of long COVID don't meet the definition because they're not serious enough, essentially. But it will be the same as nearly every other condition, where you'd be looking at reasonable adjustments, getting medical advice if necessary, and considering all those kind of additional things that you might put in place to support someone in that situation. So that's a quick summary of the kind of issues that we talked about. Those three strands of consultation, medical evidence, and business need are really important in terms of an audit trail for justifying decisions and steps that you take in relation to managing absence. And that's why it says, recording all steps. Audit trail is absolutely key to this, so you can explain why you did what you did in that procedure, and then just watching out for some of those tricky issues as we go. So this is the highlight now. James is back to talk to us about some of the cases, and we'll swap between us a little, but some highlights from the Employment Tribunal just to finish us off.
Yes, thanks, Nick. Before I talk about the cases, there's 3 cases I'm going to talk about to Nick. One, just a reminder to everyone, we're going to have a bit of time at the end for question and answers. So if you've got any questions and answers that arise as we go, or that you want asking, then there's a section in the chat for the Q&A. So feel free to pop them in there, and then we'll get to them at the Q&A point, if not before. The first case we want to talk about was Rogers and Leeds laser cutting. It was basically the first COVID case before the tribunals, because for those of you that have tribunals, you'll know it's a bit of a slow burn at the moment because the pandemic caused a bit of a backlog, and the tribunal system was already struggling due to limited judicial resources, and they're playing catch up. But anyway, this case is quite an interesting one because it goes all the way back to the start of lockdown, and Mr. Rogers was off with COVID symptoms, and one of his colleagues has also had COVID, and his stance was that he wasn't going to return to work until the pandemic had eased. And this was, if you remember back to those days, was the time of the national lockdown when you were only allowed to leave the home for various reasons, one of which was going to work. Now, important context to consider this case is that it was a warehouse type working environment that the judgment described as about the size of half a football pitch. And within it was around about 5 employees. So the risk assessments suggested that social distancing should have been fairly easy. And they actually were quite thorough, laser cutting, in that they got an external consultant to do a risk assessment and putting down recommendations. And really, the only criticism that I could see in the judgment of the tribunal was that although they recommended staggering starting and stopping times, everyone did clock out presumably on the dot at whatever the finish time was, and then the records showed that. So whether there was a sort of bottleneck of clocking out. But essentially what happened in short was, because Mr. Rogers refused to go in until the pandemic eased, he was dismissed for not coming in. And critical fact is that he had less than 2 years service. And so what he had to do was try and, in the words of the advocate, Jonathan Gidney, who some of you might know, I've certainly instructed him before, was shoehorn his case under the health and safety legislation. And what he had to do was establish that he reasonably believed there to be serious and imminent danger, and that's why he wouldn't attend the workplace. And that because he was dismissed for not attending the workplace in circumstances of serious and imminent danger, it would be automatically unfair. And he, in short, failed at both the Employment Tribunal and the Employment Appeal Tribunal for reasons that you probably guessed from my analysis of the facts and the warehouse. They essentially found that there wasn't an immediate and serious risk of danger, and that he couldn't have reasonably believed there was. And the tribunal took the view that what he was just describing was the national situation, not his workplace situation. And he did have legitimate concerns regarding his family, as many people did, and not wishing to bring COVID home. But he wasn't able to identify anything in the workplace that was specifically a risk. And he didn't engage with his employer at all about specific concerns or why he disagreed with the risk assessment, which said you could have worked safely following the recommendations. So he was unable to establish his case, and this was upheld recently in the Employment Appeals Tribunal. The next case is over to Nick on a different topic.
Yeah, so this one is Mellor and MFG Academies Trust. Quite a shocking one in this day and age. So this was a teacher who returned from maternity leave, Ms. Mellor, and she requested a room to express breast milk, and no room was provided by the school. And she was basically told that she could either express in the school toilets or in her car. Again, understandably, she mainly used the toilets as it was too cold in the car and she was concerned about being seen. I'm assuming the car park was part of the school and there would be pupils around. And she had to sit on the toilet floor to express this breast milk. And because her break was so short, so I think she had a 25-minute break, she also had to eat her lunch at the same time. Unsurprisingly, she brought claims against the school for direct and indirect sex discrimination and sex harassment. Now, interestingly, one of the school's witnesses described the fact that she had to express in the toilets as mortifying, which may well have sunk the the claim from a sympathy point of view pretty early, because that's not usually good when the employer's witnesses are describing the situation as that. And unsurprisingly, the tribunal found that the school had subjected her to unwanted conduct by forcing her to express milk in the toilets or in the car park, and that related to her sex. The school's behaviour also had the effect of creating a degrading or humiliating environment, and those 2 points together essentially made out the claim of harassment. So that was successful. Now, interestingly, the claims for direct and indirect sex discrimination didn't succeed. That was more on a kind of technical point around the fact that they hadn't done this because she was female and they didn't have a policy which put her at a disadvantage. But clearly, the sexual harassment side had been made out. And now, in some ways, this isn't a novel sort of legal point, but it is certainly quite shocking that in 2021, an employer wasn't dealing with that kind of situation better, and a reminder that actually, whatever happened there, that employer certainly was way off the mark in terms of accommodating, someone in that situation. Then we're over to James for some bad language.
Well, I'm certainly no intention of swearing, Nick, but I think everyone can read the slide. And this is a case that many of you are probably familiar with from the press recently. It's worth bearing in mind that this is just a decision of the employment tribunal. It's so new that if it is going to be appealed, it won't have had any chance to sort of filter through the system yet. So it could be one that comes back. Essentially, it all boiled down to a big row between Mr. Finn and his supervisor, Jamie King. And the quote on the slide is the bit that caught the press. In fact, there was quite a bit of arguing, and it was all quite unsavoury. And similar to the case I mentioned previously, the COVID case, laser cutting, the employee, Mr. Finn, he had less than 2 years service. So it was another example of an employee looking to see what claims he could bring, when the more obvious one would have perhaps been unfair dismissal if he'd have resigned as a result of this row and claimed constructive unfair dismissal. But with the absence of a 2-year service, the ordinary unfair dismissal case, so to speak, didn't exist. Where this case caught the press was, you probably read that it was upheld that the comment constituted harassment on the grounds of sex, and a lot of people took the view of, well, where do we draw the line? Is boldness now harassment? And I suppose that's one thing that sometimes when the press gets very excited about these types of things, there is no ban on using the term bold, and if you called someone bold, it wouldn't necessarily be harassment. What we do need to do, though, is go back to the slightly boring legal definition, which is a person harasses another if they engage in unwanted conduct related to a relevant protected characteristic, and the conduct has the purpose of effect of violating the person's dignity or creating an intimidating, hostile, degrading, humiliating, or intimidating environment. Now, most of that test was quite easily established in this test, the degrading environment. The whole thing hinged, at least this part of it, there are other claims, as the slide mentioned, in issue, but the one that's interesting is the harassment claim, was whether the comment related to sex. And one of the things that the press picked up was that the employment judge, the amusingly named Jonathan Brain, and the two lay members, because it was a discrimination claim, it was before a full panel, were all male, and apparently, although I need to verify this, or suffering or starting to suffer from baldness. So whether or not that influenced their decision, who knows? And if it's appealed, it'd be interesting to see whether they shoehorn it to one of the many female appellate judges, just to give the reverse view. But their decision was that essentially that referring to someone's baldness was inherently related to the male sex. And the reasoning on this is what I think could be attacked in an appeal was largely along the lines of that males are much more likely to be bald than women, and therefore it is inherently related to men, even though obviously women could suffer from baldness. And I think that could come under attack. But where the sort of the reasoning in the press perhaps missed is that this point about harassment just needs to be related to a characteristic, and certain comments that could relate to any characteristic could or could not be harassing if they create the hostile, degrading environment. So with harassment claims, context is almost always everything. And although it's largely a subjective test, how did the person who's claiming harassment feel? There is a slight nuance in that you do have to look to see whether or not that perception was reasonable in the circumstances that were available. So there is a slight objective element. So it's quite a nuanced test, harassment. So it'll be interesting to see if that's appealed. But it will focus narrowly on this point of whether baldness is inherently related to men or not. So watch this space on the baldness case. In answer to Wendy's question, no, I do not know. I'm not sure if they've had or dealt with the issue of remedy. But if you want to know, if you type the name of the case into the Employment Tribunal website, all judgments are now online. So if it does go through to a remedy hearing, that'll be a matter of public record how much he's awarded if it's not already there. And I think that's it for the cases. We've got some small other updates, just on topical things. The first one, statutory code of practice on fire and rehire. Another issue where the press confused a lot of people over the P&O situation. I'm sure most of you know P&O made redundant a large number of staff, and their plan was essentially to replace them with cheaper labour from elsewhere. And everyone then got very, very upset about this practice of fire and rehire. But the thing was that there was no fire and rehire. There was just fire. They missed the rehire bit. So I was very confused why everyone was getting upset about that. I mean, people do have a point, though. Fire and rehire is a practice that employers can do, and I quote, relatively easily. It's not that difficult to effect mass change to terms and conditions. And if people don't accept it, potentially dismiss and re-engage, because the way you defend an unfair dismissal claim in that circumstances isn't that hard, because as the employer, you only have to establish sound business reasons for the change to terms. You don't need to, for example, establish that the change to terms was crucial to business survival, e.g. we'd have gone bust if we didn't reduce pay or take away benefits, etc. So there is perhaps something there about fire and rehire, but I'm not entirely clear how Parliament intends to change that, because it's all based on really long-standing law on unfair dismissal, which we've had for years and years. So it'd be interesting to see when, quote, parliamentary time allows, what they come up with there. And similarly, in other updates, it's a bit thin on the ground, really. Those of you who looked into the Queen's Speech and Employment Bill will have seen there's almost nothing concrete to look out for, and instead there's going to be a review led by Matt Warman MP. And so it really is a watch this space, and you do wonder where employment reform really fits on the government's current agenda, given all the other issues more at the top of the press at the moment. So back to Nick to wrap up.
Thanks, James. Just a couple of final points, and then we should land just about on time at 11 o'clock. So one of the things that we've noticed, this is more of a trend than an update, is that clearly lots of people are moving jobs at the minute. The Great Resignation, as it's being called, may well be a thing, and you just have to spend a little bit of time on LinkedIn to see all of the announcements of people starting new roles. Clearly very active job market, salary pressures for employers, and some incredible offers being made to employees to move, as well as that obvious shortage of talent. And what we're seeing an increasing number of inquiries about is when people leave, whether they can be prevented from joining competitors, taking confidential information, customer lists, or in fact other employees. And we just thought it was worth flagging that, this is an important protection of your business interests, essentially. And if you don't have some of this stuff lined up, it may be that actually your ability to take action is limited. And again, a lot of people think restrictive covenants or non-compete clauses aren't really worth the paper they're written on. And that can be the case if they're written badly, or in fact, they don't exist at all. Gordon's on the call with us today from Actons, who helps us in what I describe as the proper courts, so not the employment tribunals with this stuff. And he's had a number of inquiries recently where the clauses either haven't been drafted correctly, they haven't been updated to fit with the role that the person's actually doing now, because they were given at the outset of their employment and they've been promoted since, or in fact there just isn't evidence of the breach. So it's really helpful if the employer has evidence that the person is in breach of those restrictions. So the key one is having them in the contract, and sometimes that's a deterrent, if nothing else, even if you decide not to take action. But having them tailored well so they don't go too far and they're not unreasonable, but they do protect the interests that you have. And we're seeing a lot of people looking at that as part of a review at the minute, and certainly getting an increased number of inquiries as to, what can we do? This person's just walked out, they've taken this stuff, or they're joining a competitor, and we're really worried about it. So it's worth looking at now. And then finally, before we go to some Q&A, do fire the questions through if you do have any. I think James is very adaptly dealt with some as we've gone. What's on offer? So that's just a final slide to say some of the things that we're looking at the minute and we're helping clients with. We're running a free employment contract and employee handbook review. Again, many employment lawyers offer that as time goes by, but essentially we're happy to look at those, highlight the kind of areas that you might want to look at improving or where there are gaps. That's free of charge, and then obviously it may be that we can help you sort those out. We're also doing a lot of this kind of stuff, so training both online and in person, depending on what works best. Just even yesterday we were talking about some of that with a new client, which was great. For the HR professionals amongst you, which is I think the majority of the people on the call, we also run something called the East Midlands HR Network with a couple of other organisations, and that's just a great way of meeting other HR people, sharing your experiences, helping each other out, and kind of giving back to the profession. So hopefully Matt might be able to post a link to the website for the East Midlands HR Network and put him on the spot there, because I don't think that was planned, but hopefully he'll be able to do that so you guys can see that. And then also we're launching something new which we've called the HRD Talks, and what we're doing is lining up some HR directors, people directors, that essentially I will interview and kind of run a podcast or video interview where they share their story, how they've got to where they are today, advice they might give to people who are following them, talking through some of the challenges that HR directors are facing at the moment. So we're really excited about that, and obviously you'll see plenty of that on LinkedIn and various other places. Matt, thank you for posting the HR Network link. So that's there in the chat, guys, if you want to see that. And I mentioned LinkedIn. Obviously, if you've enjoyed the session, it would be great to have some feedback either in the chat here, or if you're up for it, tag us on LinkedIn, share that you were at the event today. It's obviously good PR for us, and we'd be really grateful for that if it's been a useful session. And I think we're slightly over, maybe 2 minutes over. I'm looking at the questions. It's basically thank yous so far, as I can see. James, I don't know if you've had a better view of that. If anybody does have any questions, fire them.
Yeah, no, there's nothing in the Q&A tag, but in the chat there's a few things, but I think we've answered them as we've gone.
No problem. Well, obviously, if there are any other queries that you have that maybe aren't appropriate for the public setting, as sometimes the HR people issues are, then obviously do get in touch. We're really grateful for you joining us and sticking with us to the end online. Hopefully it's been useful, and we'll hopefully see you all again soon. Thank you very much.